I want to talk to you about it. It won't take long.
We're on a record in cause number 326-662, cause number 327-054. Both cases are style of state of Texas versus Jonathan Lee Roberts. Is that your full name?
Yes, sir.
Okay, how you doing, Mr. Roberts?
Okay.
You doing all right? All right, Mr. Roberts. Do we have bond conditions in this case? You're here with your attorney, Mr. Charles Rojas. Mr. Rojas, how are you doing?
Doing good, Your Honor.
That's good. Mr. Rojas, do you have an announcement that you would like to make?
We do, Your Honor. Mr. Roberts has indicated that the complaining witness in the family assault has already signed one affidavit contradicting some of the facts in the case, but she would also like to sign a non-prosecution affidavit and have time to take the options classes. So we're asking for a reset to give her time to do that.
Okay, so, state, you're saying you need to reset, how long? You said to take the options class.
I don't know when the options class is
But how long are
available
they?
next. It's a day,
Okay.
but I have not gotten to talk to the victim in this case yet up until towards the beginning of this month or into last month. He had a pending felony along with these. He's resolved the felony, and so I have not had an opportunity to look into what Mr. Rojas is saying.
Mr. Robert has indicated that he'd like at least 60 days, Judge.
Okay, you say he would like 60 days.
Yes, sir.
Okay, I'm just trying to figure out, are we trying to reset the case depending on the options class, not based on
I
how
don't
much
know
time
when
he
the
wants?
next one's gonna be. 60 days is
How
fine.
long is the,
It's usually not something that's put before the court. It's something that's done with our office.
Right.
For the victims.
right,
And
right, I know,
it's
y'all,
just
what y'all do is
okay.
y'all just bring the person in, interview, set up a date for them to go take the class. Is a class like a one-time event thing, or?
Yes,
Okay, and that's through,
our office, and I don't know the date for it.
Has
because
he,
it varies for dates, and it's not something the defendant does, it's something for the victim.
right, so I'm gonna just give them a standard reset on this here.
Okay, and we'll see if it's done. I don't know when the next option class is, Judge, but if
Right.
if they don't have one between now and the next court date, I'll let the court know we can get a reset.
Okay, what's the day, is the 19th? And I noticed that he did not have any bond conditions in this case. I'm going to give him some bond conditions. What's her name? Roberts. Okay. Is it Jessica Bush?
And I know one of the typical bond conditions is no contact with the victim, but Mr. Roberts telling me they do live together and have lived together even after this incident happened.
Okay. Okay, let me go ahead on, we could take at those conditions. I'm going to go through those conditions with you. Okay, Mr. Roberts, I know your full name is Jonathan Lee Roberts, is that correct?
Yes.
Mr. Roberts, do you see the document that's before you is titled Standard Bond Conditions in County Code Law Number 2?
Yes.
And I will go over these conditions with you. And it reads, following arrest and or accusation in County Code Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
And condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. And that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, subsection A2, subsection C2. Do you understand that condition? And condition number 3, the defendant shall not communicate, either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. The alleged victim in this case is Jessica Bushnell. Do you understand that?
Yes.
And condition number 4 doesn't apply to you because that only applies to DWI case, and your case is a family assault, is an assault family violence case, is not a DWI case. All right? Now, those conditions are, get rid of it. He has the condition, I have to make a copy. Okay,
Judge, again, as to condition 3, we would ask that the court waive that on the basis that the defendant and the complainant are boyfriend and girlfriend, they're living together.
State, what's your response?
I don't have enough information to be able to make a rule.
Okay, so I
She's
just,
indicated that she's gonna come in and sign the
Well,
prosecution take
well,
action classes.
okay. At this time, that condition is gonna stay in effect. Okay,
If Judge, if she were to come today and sign at least the non-prosecution and get signed up for the option class, would the court revisit that?
well, the state, I mean, we could always revisit stuff, but I mean, the state is not in a position to,
But I'm
I
saying
mean,
if
if you
she,
gave me till maybe 1 o'clock and I could have time to communicate with the victim, we could maybe have a short hearing on it for Zoom.
we can do that.
because my understanding is that she's in the parking lot and she's willing to come up and sign whatever and talk to whoever she needs to right now, if we can take care of that right now.
I don't, state, you want to, us to just hold off on entering the order until you have an opportunity to talk to the victim in this case?
If that's what the court's willing to do, then
I mean, we'll hold, I mean, right now, the state would like to talk to his victim. Okay.
And Mr. Robert can wait here until we get the victim talked to and see what she's willing to do.
Okay, but okay, we'll do
And
that.
if that's not true, then obviously the condition will stay.
Well, we'll see what the state's position is at that point, so we'll hold off at this time. Okay, all right.
You want her
Well-
in here or upstairs?
yeah, tell him.
We're on the record. Okay, we're on the record in cause number 327-356. But hold on a minute. Whoever's on the Zoom, would you please put your mic on mute?
Oh, yes, yes, sir. I'm sorry.
Okay. All right, we're on the record in cause number 327-356. The case is styled the state of Texas versus Jasmine Kyle Sanders. And Mr. Pepper, what was Mr. Sanders here? Would you please call the name of Jasmine Kyle Sanders?
Judge, she is not here.
Oh, she-
My office received a call that she's actually in the hospital. She had some kidney issues. I don't have any proof of that because it just happened this morning, but if the court will give me a day or two, I'm sure she can fax something to my office and I can present that to the court, showing that she actually is in the hospital.
Okay, so what we need to do, we'll give you, you think you may be able to get until either today or tomorrow? That's what you said?
She's in the hospital right now. I don't know. I would assume so. I don't know how long she's gonna be there, but I would think I can get something at least saying that she's there by
Right.
tomorrow.
Okay, so we'll hold off on forfeiting the bond till you get some confirmation that she is actually, I guess, in the hospital.
Okay.
Okay, so State, you have any objections?
No, Your Honor.
Okay, no objections. All right,
I'll get that to you tomorrow.
okay. Okay. Yes, I'm trying to get to it. What's this one? We're going to reckon two cases. First case is cause number 328806. Second case is cause number, oop, strike that. It's one case. Case number is cause number 326250. And the case is styled the State of Texas versus Eva L. Flores. Okay, Ms. Flores, would you please raise your right hand? Ms. Flores, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God? You have to speak up.
Yes.
Okay, you may put your hand down. Okay, Ms. Flores, how are you doing? You doing fine? Okay, now let's see. Ms. Flores, I never represented you before in a case, have I?
He's not, he's never been your lawyer. The judge has never been your lawyer.
Oh, okay.
Might wish he would have been after today.
I was asking. Okay, so I've never represented you, is that correct?
That is correct.
Okay, have I ever met you before?
I don't know. Maybe.
Okay, so you say maybe, but if I had met you, would you have remembered that? You wouldn't have remembered that, okay. So obviously, we never had no conversations or anything of that nature, is that correct? Okay, now, Ms. Flores, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Okay, Ms. Flores, you may put your hand down. How are you doing, Ms. Flores? You doing fine?
Yes.
Okay, now, Ms. Flores, let's see, I have before me, let me get these documents on. And Ms. Flores, I just asked those questions because you kind of looked familiar. And I was just confirming that you weren't a person that I know. Now, let me ask you, see, you're not have you ever interpreted, have any interpretation work
No.
for the court? Okay, all right. Now, Ms. Flores, I have before me an information, that's the charging instrument that alleges that on or about March 22nd of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration of 0.14 or 0.15 or more.
Your Honor,
Oh.
as part of the plea agreement, the state's abandoning
Oh.
the enhancement in this and playing it to a simple DWI first.
Okay, I need to scrape through this here. So it's the DWI first?
Yes,
Yes,
Your
Your
Honor.
Okay. So Ms. Flores, let me repeat. The state had filed a DWI, a Class A misdemeanor DWI with an enhancement of 0.15 or more. However, the state is abandoning that portion of the information. What that means is they're going to charge you with a lesser included offense. You're going to be charged, instead of being charged with a Class A misdemeanor, you're going to be charged with a Class B misdemeanor, which is a lesser charge. Do you understand that? Now, so the state is charging you with the Class B misdemeanor offense of driving while intoxicated, which they allege occurred on or about March 27 of 2020 while you were operating a motor vehicle in a public place in Jefferson County, Texas. Ms. Flores, do you understand what you've been charged with?
Yes.
And to this charge, Ms. Flores, how do you plead? Guilty, not guilty, no contest?
Guilty.
She said guilty?
Guilty, yes.
Okay, guilty, okay. I just need to make this note on here, the state is abandoning. Paragraph. Now, Ms. Flores, I have before me, well, first of all, Ms. Flores, are you pleading guilty freely and voluntarily? You have to speak up.
Yes.
And are you pleading guilty because you're guilty? You wanna, your attorney?
He's asking if you're pleading guilty because you are guilty, just of the DWI. We're not talking about the other things, just the DWI.
Yes.
Yes, okay. Now, Ms. Flores, I have before me a document that is titled the misdemeanor plea admonishments, also referred to as State's Exhibit Number 1. Now, do you recognize this document? Now, I wrote on this document, and the stuff that's written on this document right here states that the state is abandoning the enhancement paragraph, and I initialed it right here. So, but for that, do you recognize this document?
Remember, that's what we said.
Okay. And on page 2 of the same document, are these your initials on the line that's checked guilty?
Yes.
And on the next page of the same document, Ms. Flores, this top line up here that says defendant, is that your signature? Okay. And let's see. Okay. Now, Ms. Flores, I have another document before me. This document is titled the Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes.
And is this your signature above the line that says defendant on this document? There's one box that's checked at the top of this document. That box states that this is a plea bargain case and you have no right of appeal. Do you understand that? I have another document here. This document is titled the Discovery Certification. Do you recognize this document?
Yes.
And on page, excuse me, and on the second line of this document, is that your signature?
Yes, sir.
Now, prior to signing and initialing these documents, did your attorney, Mr. Crenshaw, go over these documents with you? You said yes? Okay. And did you read and understand everything that Mr. Crenshaw went over in these documents? And is everything in these documents true and correct to the best of your knowledge?
Yes.
State, I have before me State's Exhibit Number 1. State, you like to offer State's Exhibit Number 1?
Yes, Your Honor.
No objection, Your Honor.
Okay, no objection. State's Exhibit Number 1 will be admitted. Mr. Crenshaw, you advised in counsel, Ms. Flores, is there any evidence that she is currently mentally incompetent to stand trial?
No, none at all, Your Honor.
Ms. Flores, your attorney, Mr. Crenshaw, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation? Okay. Ms. Flores, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt, state, do we have a plea bargain agreement?
Yes, Your Honor, it's for 180 days over, to be probated over 18 months, $500 fine, 40 hours community service, the DWI education course, drug and alcohol assessment. And as part of this agreement, the state is dismissing a felony case, cause number 20-35122.
That's our agreement, Your Honor.
Okay, so, what's it, DWI Ed? Could you repeat that offer again?
Yes, Your Honor, it's 180 days to be probated over 18 months, a $500 fine, 40 hours community service, DWI education, and drug and alcohol assessment. And then we're dismissing a felony cause number 20-35122.
Drug and alcohol. 20-33. Dismiss. Okay. And you're not requiring a interlock, is that correct?
No, this was something that was worked out between Fino and Mr. Crenshaw, and then the terms were worked out between Mr. Shearer and Mr. Crenshaw, and it's my understanding that since we were not offering deferred in this, we were not going to have the interlock on it.
Well, yeah, but I'm looking at this this BAC .252, if that's was correct. I don't know if I'm gonna go along with this. It's that BAC is .252.
Your Honor, I don't know if Mr. Crenshaw is willing, but if you would like us to take a recess and maybe we can discuss some.
Well, if that's what, yeah, if that's what you want to do.
With the
that's fine.
judge,
No, not with me.
No.
No, you're just talking about y'all.
I didn't know if you wanted.
Yeah, I'm not gonna
discuss it
follow
further.
the plea bargain agreement at this time.
okay, Judge. Our
Yeah.
understanding
And
was
then,
you would
you
not
know,
accept a deferred plea agreement?
If, no, I'm saying if I don't follow the plea bargain agreement, then obviously, she has a right to withdraw or take back a plea at this time.
Understood, Your Honor, and that's what we'll do. Just so the court's aware, our original agreement was deferred. That's what I came in here with today, wanting to do that. I was informed by the state you would not accept a deferred plea agreement on a DWI lesser included. Therefore, this is the agreement that we worked.
That's what you were informed.
That's what I was informed.
We also talked about, and I also heard Ray talk about, that we didn't think that the law would also allow for deferred in this type of
I don't
situation.
think
Oh.
the law wouldn't allow.
All right. Oh, I thought you said they said I wouldn't. Oh, okay. They don't, I mean, unless they mind readers, I don't know if they know what I accept or would not accept. But I do know that, we'll follow the law based on, we apply the facts to the law.
Right,
and then
if-
whatever-
and if we proceed on a lesser included, I don't understand how the
Well,
law would be
yeah.
any different to that.
Well, I don't know, but y'all can,
Legislature, allowed deferreds in an effort to try to resolve DWI cases, and now it seems like it's nearly impossible to
Right,
get a
but the
deferred.
legislature also put in the law that you have to have a blood alcohol concentration below 0.15 to qualify. It didn't say you couldn't be charged with a class A on it. It put specifically. the
My
BAC.
client would like to withdraw her plea at this
Okay.
time and put it
Okay.
on the trial docket. Your Honor.
okay, we can do that. Okay, we'll reset the case. Give us a trial setting.
August the 16th.
I have a trial in federal court on August 17th, Judge.
Oh.
Do we have a September setting, please?
Yeah.
Have on September.
Oh, let me do this here. We get our dates from the administrative law, and I think we only so far out. But what I'm saying is we can give you a date. Only thing I can't guarantee that's going to be an approved date.
Oh, how about we just do August 16th, and then if my trial goes on the 17th, I'll let you know.
Well, they
weeks in
federal,
advance.
they trump us anyway, so.
But it's a special setting, and we just got it the other day. It's kind of a mess.
We'll have new-
Wonderful.
Let's do this here. What you got?
I said, because we'll have new dates after.
Hold on, let me do this here. Do you have that, the docket with our dates that we're gonna be requesting?
It stops at August 16th.
Oh,
So
oh,
by that time, we'll have, submitted new dates.
we'll have some new dates in the next month. Now, let me do this here. What I could do is put you like on a pretrial conference docket. And then probably when you come back for the pretrial conference docket, we'll have some dates.
Perfect.
Okay, let's,
I just was going to ask, because I'm not familiar since this wasn't my case, is this, all the same incident as the felony?
Yes.
case? Okay, are you going to be announcing trial now in felony? Busted?
I don't know, actually.
Okay.
yeah,
I'm
they-
I
just
could have
asking, just
10
to
minutes
try-
to try to think about my strategy now that this is all unraveled.
Okay,
okay, so let's, oh, she was gonna say something?
They have a reset the felony lawsuit as well.
They have?
Or what's the felony?
I had already informed the court that the case was going to be
Oh,
dismissed. I
okay.
have to go down there and let them know that it's not going to be dismissed, and no idea where the felony will end up.
Okay. So let's hold off on, we're gonna hold off on giving you, we can give you a pretrial conference date. Let's do that.
Thank you.
And then, how much time do you need? Like 45 days, something like that? 60 for 35, 30?
It's up, whenever y'all would have your new trial date.
You want him to give his reset with the felony first and then we reset the misdemeanor? You want to keep them together?
Yes.
Okay, do that then. Then we'll let you get your reset with the felony and then you can come back down here and announce on the,
Okay. All right.
okay.
Thank you.
All right, you're welcome.
I need to print it.
Person that's on Zoom,
That's true.
what's your name?
I'll shrink.
You're on mute.
No, I'll shrink it.
You're on mute. We can't hear you.
Okay, Natasha Griffin.
Natasha Griffin?
Yes, sir.
Okay, just put your mic, okay, put your mic on mute and then we'll come back to you. We just need to find out who you were.
Okay, thank you.
Bye. Ms. Griffin, we don't see your name on this docket. You may be in another court. Whose court are you supposed to be in? Your mic is on mute.
Yes, sir. This is my first time doing this. I think it's for tomorrow, Your Honor. The
Oh,
20th.
well, hold on, wait, Ms. Griffin, we don't, you would have to zoom in on tomorrow.
Okay.
Oh, okay. Oh, no, it's set for the arraignment, they said? Yeah, on arraignments, you have to appear in person.
No, they didn't give me no arraignment. They gave me a Zoom ID.
Who gave you a Zoom ID? Yeah, I don't know who gave you the Zoom ID, but if it's an arraignment, you have to be here in person.
Okay, because what is my bail bonds were called and got all the information. It's just for a failure to ID.
I know, but you have to appear in person for arraignment on tomorrow. Okay?
I already been done all that.
Well, we have you set for an arraignment on tomorrow, and as I said earlier, you have to appear in person.
Okay, and I told them that when I called. If we in quarantine,
Mr., hold on. Just hold on a minute.
yes, sir, because I'm in quarantine. Hold on, man.
Huh? What you said?
Now, Miss Griffin,
Uh-huh.
what we need you to do is, I know you just informed us of some information. I don't know, you have to be mindful that we're on YouTube.
Uh-huh.
And you can call the court. What's our court number? Okay, call 835-8607.
Hold on, let me get a pen, Your Honor. All right.
Will love it. The perfect setting for the perfect party.
Yeah, because we're on quarantine and she called and got my Zoom ID and that's what they said I need to do. Okay, what is it? Number, Judge?
This is 835-807.
835-8007.
835-8607.
Uh-huh.
And the person's name that you'll be talking to is Mel.
Okay,
All right, just call that number. Okay.
thank you.
Have a blessed day.